Case 1. Damian McDaniel. Birmingham, Alabama had seen violence before, but what unfolded between July 2023 and October 2024 was something different entirely. A pattern so relentless, so calculated, that by the time investigators connected the pieces, one name kept appearing at crime scenes across the city. It wasn't random, it wasn't spontaneous, and it wouldn't stop until someone made it stop. Damian McDaniel was 23 years old when the accusations began to mount. To those who knew him casually, he seemed like just another young man navigating life in Birmingham. But beneath that surface, prosecutors would later argue, was someone methodically erasing lives across the city. The timeline they eventually constructed painted a chilling picture of escalation that began with a firefighter responding to his morning shift and ended with mass casualties that shook an entire community to its core. July 12th, 2023. Birmingham Fire Station 9. It was 8:30 in the morning, just 30 minutes after shift change. 3 firefighters were starting their 24-hour rotation, going through their usual routines. The bay doors were open, the station doors were unlocked. It was a normal summer morning until 2 shots rang out. Jordan Melton and Jamal Jones, both in uniform, both unarmed, were struck where they stood. Melton fought for his life for 5 days before passing away in the hospital. Jones survived, but barely. No suspect was immediately identified. The station had security footage, but the shooter had been careful. The investigation into that morning would take months. But in the meantime, more violence erupted across Birmingham. November 27th, 2023. Reginald Bryant, 52, was found behind a home on Closure Lane with fatal wounds. Witnesses reported seeing multiple suspects approaching him before shots were fired. The scene suggested a robbery gone catastrophically wrong. Then came 2024, and the pace quickened. January 10th. Mia Nixon, 21 years old, was discovered in her own driveway on Greencrest Turn, just after 2 in the morning. She had been targeted, investigators would later determine, though the motive remained unclear. February 14th, Valentine's Day. Christian Norris and Angelia Webster, both 20, left a residence in the Ensley area to go to a movie theater. They never arrived. 2 days later, their bodies were found inside their vehicle in the Wylam neighborhood. Webster was 5 months pregnant. The brutality of the discovery sent shockwaves through Birmingham, and authorities began to suspect these cases weren't isolated incidents. April 9th. Anthony Love Jr. clocked out from his shift at a UPS facility on Inglewood Lane. He walked to his car in the parking lot, completely unaware he was being watched. Prosecutors would later describe his death as a murder for hire, a calculated execution carried out in broad daylight. Security. Cameras captured shadows and movement, but identifying the shooter would take time. July 13th, 2024. The violence reached a horrifying new level. 4 people were killed and 10 others wounded at Trendsetter's Lounge on 27th Street North during a birthday party. Larandis Anderson, Stevie McGee, Markeisha Gettings, and Angela Weatherspoon all lost their lives when gunfire erupted from the street into the crowded venue. Witnesses describe chaos, screaming, bodies falling. The scene was unlike anything Birmingham had experienced in recent memory. Investigators believed at least one suspect had driven by and opened fire indiscriminately. The venue, they later discovered, was unlicensed and operating without proper safety measures. August 13th. Another life taken. September 19th. Another victim at a bar and lounge. And then September 21st, 2024. 5 Points South, the Hush Lounge. It was approaching 9 in the evening when shots rang out in one of Birmingham's busiest entertainment districts. 4 more people were killed, and 17 others were injured in what would become one of the deadliest mass shootings in Alabama's modern history. Anitra Holloman, Taj Booker, Carlos McCain, and Roderick Patterson Jr. all died at the scene. The sheer scale of the carnage sent the city into a state of alarm. Birmingham police had been building their case quietly, across 18 separate incidents spanning just over a year. Patterns emerged. Ballistics connected some cases. Witness statements overlapped in others. Surveillance footage placed similar vehicles at multiple scenes. And one name kept surfacing: Damian McDaniel. When authorities finally made the connection public, the numbers were staggering. 18 people were now tied to his alleged crimes. Not 18 incidents, 18 lives. In February 2025, Birmingham police announced that McDaniel had been charged with capital murder in the death of firefighter Jordan Melton. It was a breakthrough that opened the floodgates. Additional charges followed rapidly. By May, McDaniel faced accusations connected to all 18 deaths, including 2 mass shootings, the firefighter ambush, the Valentine's Day couple, and the murder-for-hire plot. Prosecutors stated publicly that McDaniel and his alleged accomplices were responsible for approximately 30% of all murders in Birmingham between July and September of 2024 alone. The details that emerged were damning. Witness testimony placed him at or near multiple crime scenes. Co-defendants provided statements implicating him in various plots. Digital evidence suggested planning and coordination. And in several cases, surveillance footage captured individuals matching descriptions linked to McDaniel's known associates. Birmingham police described him as the central figure in a wave of violence that left families shattered and a community traumatized. McDaniel maintained his innocence throughout. From behind bars, he posted on social media claiming he had been framed, that investigators had manipulated evidence, that he was being made a scapegoat for unsolved crimes. He pointed to his probation record, noting he had reported on time every month until his arrest. He denied being involved in any of the incidents, but prosecutors disagreed. They argued the evidence was overwhelming, the connections undeniable. During a status hearing in 2025, a judge set McDaniel's first trial date for April 6, 2026. The charge: capital murder in connection with the Trendsetters Lounge mass shooting. His defense attorneys raised concerns about finding an impartial jury, noting that Birmingham had suffered one of its deadliest years on record in 2024 with 151 murders, and that McDaniel's name had become synonymous with that violence. The judge acknowledged the difficulty, but cautioned against emptying the city in search of jurors with no knowledge of the case. As McDaniel awaits trial, the question of justice hangs heavy over Birmingham. Prosecutors are seeking the death penalty. If convicted, he would face execution or life without parole. The families of 18 victims wait for closure. A city waits for answers. And a 23-year-old man sits in a maximum security facility, charged with orchestrating one of the most devastating crime sprees in Alabama history. But Birmingham's darkness extended beyond one man's alleged rampage. In a quiet town north of Huntsville, another young person would commit an act so incomprehensible that it would redefine what a community thought it knew about evil. Case 2, Mason Sisk, September 2nd, 2019. Elkmont, Alabama. A town of 500 residents where everyone knew everyone, where families felt safe enough to leave doors unlocked, where tragedy was something that happened elsewhere. Until it wasn't. 14-year-old Mason Sisk was quiet that night. Not unusual for a teenager, his family might have thought. What they didn't know was that within hours, their small world would end in silence and bloodshed, and the boy they thought they knew would become unrecognizable. Mason had grown up in this home with his father, John Wayne Sisk, and his stepmother, Mary. They had built what appeared to be a typical American family, complete with 3 younger children, 6-year-old Kane, 4-year-old Aurora, and 6-month-old Coulson, still small enough to sleep in a crib. On the surface, they seemed ordinary. But behind closed doors, tension had been building. Court records would later reveal disturbing patterns. Mason had allegedly tried to poison his stepmother with peanut butter, despite her severe allergy. He had stolen rings from her. He had taken a weapon from his grandmother's house, and he had shown what prosecutors called anger control issues with his younger brother. On that Tuesday night, in early September, the family went to bed as usual. The house on Ridge Road sat in a rural area northwest of Huntsville, not far from the Tennessee border. It was the kind of place where neighbors respected each other's privacy, where the sound of crickets was louder than traffic. Around 10 that evening, Mason was seen running from the house. He flagged down someone nearby, frantic, claiming something terrible had happened. When authorities arrived, they found a scene that would haunt investigators for years. All 5 members of Mason's family had been shot in the head as they lay in their beds. John Wayne Sisk, 38, Mary Sisk, 35, Kane, Aurora, and baby Coulson. Each one had been killed execution style while they slept. The home was quiet now, eerily still. There was no sign of forced entry, no evidence of robbery, just 5 bodies and a 14-year-old boy with a story. Mason told police he had been in the basement playing video games when he heard gunshots. He said he ran outside and saw a vehicle speeding away. He described it in detail, color, size, direction. For a brief moment, investigators considered his account, but inconsistencies began to surface almost immediately. His timeline didn't match the evidence. His description of the vehicle couldn't be corroborated. And when forensic teams processed the scene, they found no indication that anyone else had been in the house. Limestone County Sheriff's deputies brought Mason in for questioning. He was calm, almost too calm. When detectives pressed him, his story began to shift. Eventually, in a video-recorded interview that would later be played in court, Mason admitted the truth. "Yeah, they argue a lot, and I got fed up with it," he said. "And the kids were going through a lot." It was a stunning confession from a child barely old enough to drive. He had killed his entire family because, in his words, he was tired of the fighting. But the legal system faced a dilemma. Mason was 14. Under Alabama law, juveniles charged with capital offenses are automatically tried as adults, but they cannot receive the death penalty. The question wasn't whether he would face consequences. It was what those consequences would look like. Prosecutors charged him with multiple counts of capital murder. His defense team argued that he was a traumatized child, that his statements had been obtained under duress, that he deserved treatment rather than life in prison. The case dragged on for years. A first trial in September 2022 ended in a mistrial after new evidence from Mary Sisk's cell phone became available. By then, Mason had turned 18, no longer a juvenile, but still facing charges for crimes committed as a minor. In April 2023, a second trial began. This time, the jury heard everything: the confession, the forensic evidence, the testimony from investigators who had processed the scene. They also heard about the peanut butter incident, the stolen rings, the threats Mason had allegedly made to his parents. The jury deliberated for just 2 hours before returning a verdict: guilty on multiple counts of capital murder. The decision was unanimous. Mason showed no emotion as the verdict was read. His fate now rested with Circuit Judge Chadwick Wise, who faced a rare decision. Under U.S. Supreme Court rulings, life sentences without parole for juveniles are considered inappropriate except in the rarest of cases. Judges must consider a juvenile's diminished culpability and capacity for change. But Judge Wise reviewed the evidence and concluded this was one of those rare cases. In his sentencing order, Judge Wise wrote that the crime was ghastly, disturbing, and draped in unmitigated evil. He noted that all 5 victims had been killed as they lay helpless in their beds, that Mason had methodically moved through the house, executing each family member. He noted that 3 of the victims were small children, including an infant. He wrote that the circumstances of the Sisk case are much more appalling than other cases where life sentences for juveniles had been upheld. On September 7, 2023, Judge Wise sentenced Mason Sisk to life in prison without the possibility of parole. Mason's defense team immediately filed appeals, arguing that the trial had been flawed, that evidence should have been excluded, that the sentence was unconstitutional. In December 2023, a judge dismissed their motion for a new trial. In 2024, the Alabama Court of Criminal Appeals upheld both the conviction and the sentence. Mason Sisk, now in his late teens, will spend the rest of his life behind bars. The town of Elkmont never fully recovered. Memorials were held. Vigils brought hundreds together. But the questions lingered. How does a 14-year-old commit such an act? What signs were missed? Could anything have prevented it? For the surviving family members, the pain remains unimaginable. They lost 5 people in one night at the hands of someone who should have been part of their circle of love and trust. Mason Sisk's name became a cautionary reminder that evil doesn't always announce itself, that it can hide behind young faces and quiet demeanors, and that sometimes the most horrifying violence comes from those we least suspect. If a teenager could methodically execute his entire family, then perhaps evil wore more masks than anyone wanted to believe, including the mask of a disgruntled worker who believed his coworkers were spreading rumors. Case 3. Alan Eugene Miller. August 5, 1999. Pelham, Alabama. A suburban city just south of Birmingham, where people went to work, raised families, and assumed their biggest worry would be traffic on Highway 31. That assumption shattered before most residents had finished their morning coffee. Alan Eugene Miller was a delivery truck driver for Ferguson Enterprises, a heating and air conditioning distributor. At 34 years old, he appeared to be just another employee, going through the motions of a working-class life. But inside his mind, paranoia had been building. He believed his coworkers were spreading rumors about him, rumors he couldn't prove, rumors that, according to later testimony, may not have even existed. But to Miller, they were real enough to justify what came next. That Thursday morning, Johnny Cobb, the company's vice president, arrived at work and was preparing to enter the building when he heard loud noises and someone screaming. Before he could process what was happening, he encountered Miller at the entrance. Miller was armed with a .40 caliber Glock pistol. His words were calm, almost matter-of-fact. "I'm tired of people starting rumors on me," he said. Then he walked away, leaving Cobb standing in stunned silence. Cobb entered the building and immediately understood. Christopher Scott Yancey, 28, was under a desk. He had been shot 3 times. The first bullet had traveled through his groin and into his spine, paralyzing him instantly. He couldn't move, couldn't escape. Miller had walked up and shot him twice more. In the hallway, Cobb found Lee Holdbrooks, 32, lying face down at the end of a long trail of blood. Holdbrooks had been shot in the chest and head, but had somehow remained conscious. He crawled 25 feet toward an exit, leaving a crimson path behind him. Miller had waited, watched him struggle, then walked up and shot him in the head at close range. 9 shell casings littered the scene. 2 men were dead in a pool of their own blood. But Miller wasn't finished. He got in his truck and drove 5 miles to Post Airgas, a business where he had previously worked. There, he found Terry Jarvis, 39, his former supervisor. Jarvis didn't have time to react. Miller shot him 5 times. By the time police were alerted, Miller had killed 3 men in less than an hour. He drove off, but not far. Alabama Highway Patrol spotted his vehicle on the side of the road and pulled him over. He surrendered without resistance. Inside the truck, officers found the weapon. Miller offered no explanation beyond what he had told Cobb earlier that morning. The rumors. Always the rumors. At trial, prosecutors painted a clear picture. This wasn't a crime of passion or sudden rage. Miller had armed himself, driven to one location, executed 2 men, driven to another location, and executed a third. Each victim had been shot multiple times. Each killing had been deliberate. The defense attempted to argue insanity. A psychiatrist hired by Miller's team testified that he was mentally ill, suffering from severe paranoia. But the expert also admitted the illness wasn't severe enough to meet Alabama's legal standard for an insanity defense. Miller himself initially pleaded not guilty by reason of insanity, then withdrew the plea. The jury convicted him of capital murder in the year 2000. The evidence was overwhelming. Witnesses had seen him, his own words had been recorded, and the ballistics matched perfectly. The judge sentenced him to death. Miller was sent to Holman Correctional Facility to await execution, but his story was far from over. Alabama, like many states, had struggled for years with lethal injection protocols. Drug suppliers refused to participate, citing ethical concerns. Execution dates were set and then postponed as the state scrambled for alternatives. On September 22, 2022, Miller was scheduled to die by lethal injection. Prison staff prepared the gurney. They strapped him down, and then they tried to establish intravenous access, and tried again, and again. Miller weighed 351 pounds, and his veins proved difficult to locate. As the clock ticked toward the midnight deadline, it became clear the execution couldn't be completed on time. Alabama called it off. Miller was returned to his cell. He filed a federal lawsuit, arguing that the state had botched the procedure and that any future attempt would constitute cruel and unusual punishment. In November 2022, Alabama reached a settlement. The state agreed not to use lethal injection on Miller. Instead, they would use nitrogen hypoxia, a method that had never been tested on a human being in the United States. Miller initially challenged the protocol, but eventually dropped his lawsuit after reaching an undisclosed agreement with the state. Nitrogen hypoxia works by forcing the condemned person to breathe pure nitrogen gas, depriving the brain of oxygen until death occurs. Proponents argued it was humane, that the person would simply lose consciousness and die peacefully. Critics called it experimental and potentially torturous. Alabama had used the method only once before, on Kenneth Eugene Smith in January 2024. Witnesses described Smith shaking violently, gasping for air, his body convulsing against the restraints. The process took over 20 minutes. The images sparked international outrage. On September 26, 2024, Miller became the second person in the world to be executed by nitrogen gas. He was strapped to a gurney in the execution chamber at Holman Correctional Facility. A mask was fitted over his face. At 6:14 p.m., the nitrogen began to flow. Miller's final words, muffled by the mask, were defiant. "I didn't do anything to be in here," he said. Then the gas took over. According to witness Lauren Gill, Miller visibly struggled for roughly 2 minutes, shaking and pulling at his restraints. Then, for the next 5 to 6 minutes, he gasped intermittently for air. His breathing became shallow. Eventually, it stopped. At 6:38 p.m., he was pronounced dead. The entire process lasted approximately 16 minutes. Alabama Corrections Commissioner John Q. Hamm told reporters that everything had gone according to plan, that the shaking was expected as the body was depleted of oxygen. Critics disagreed, pointing to the prolonged gasping as evidence of suffering. Miller's execution became the 16th execution in the United States since the death penalty resumed in 1976. For the families of Lee Holdbrooks, Christopher Yancey, and Terry Jarvis, it brought a measure of closure after 25 years of waiting. Alabama Attorney General Steve Marshall issued a statement calling the execution just and appropriate, emphasizing that Miller had shown no remorse for his crimes. But the debate over nitrogen hypoxia continued. Was it a humane alternative to lethal injection, or was it a return to experimental methods that violated constitutional protections? Alan Eugene Miller went to his death maintaining his innocence, despite overwhelming evidence and his own words from 1999. He had killed 3 men because he believed they were gossiping about him. No proof was ever found of these rumors. No witnesses corroborated his claims. The paranoia that drove him to murder remained, in the end, entirely inside his own head. But the consequences were devastatingly real. 3 families destroyed, 3 lives erased, and a legacy of violence that would haunt Pelham for decades. Yet not all Alabama cases were so clear-cut. Sometimes the lines between victim and perpetrator blurred in ways that challenged the very foundation of self-defense laws. Case 4, Brittany Smith, January 16, 2018. Stevenson, Alabama. A small town near the Tennessee border where Brittany Smith, 32, was trying to rebuild her life. She was a mother of 4, recently clean from methamphetamine addiction, working to stay on track. When an acquaintance named Joshua Todd Smith called asking for help, she didn't hesitate. He was stranded in a park. It was snowing. She had just bought a puppy from him the day before. It seemed like a simple act of kindness. It would turn into the worst night of her life. Brittany and her brother Chris McCallie picked up Todd and brought him back to her house on Believer Street. They started talking about recovery, about addiction, about getting clean. Todd had his own struggles with methamphetamine. According to Brittany, the conversation took a dark turn. Todd became violent. He threw her onto a bed and choked her until she blacked out. When she regained consciousness, she was naked, lying in a pool of her own urine. She testified that Todd raped her multiple times that night. He threatened to kill her if she told anyone. He threatened to kill her family. He demanded cigarettes, asserting control like he owned the place. Brittany didn't have a car, so she called her mother, who sent Chris back over. Brittany, Todd, and Chris drove to a nearby gas station. Inside, while Todd wasn't looking, Brittany grabbed a piece of paper and wrote Todd's name on it. She slipped it to the cashier with a desperate message. If she ended up dead, this was the man, responsible. She begged the cashier not to call police, terrified of what Todd would do if he found out. They returned to Brittany's house. Chris went back to the gas station to talk to the cashier, who confirmed what Brittany had written. Enraged and protective, Chris grabbed a weapon and returned to confront Todd. The 2 men got into a physical altercation. According to Brittany, Todd put Chris in a headlock and was choking him. She screamed for them to stop. When they didn't, she grabbed the weapon from the counter and fired 3 shots. Todd collapsed. He was pronounced dead at the hospital. Brittany called 911. But here's where her case began to unravel. When the operator answered, Brittany didn't mention the assault, didn't say she'd been attacked, didn't say the word that would become central to her defense. Instead, she initially told police that Chris had been the shooter, that she was trying to protect him. She later explained this was because she knew police wouldn't perform an examination for evidence of assault unless they believed she was the victim, and she needed that examination done immediately. The strategy worked. Nurses documented over 30 bruises on her body, bite marks on her neck and chin, signs of strangulation, and secretions consistent with assault. But the lie had been recorded. It would follow her into court. The next day, Brittany admitted she had been the one to pull the trigger. She was arrested and charged with murder. Her defense team immediately began preparing a stand-your-ground defense, a legal principle in Alabama that allows individuals to use lethal force if they reasonably believe they or others are in imminent danger. Brittany's attorneys argued that she feared for her life and her brother's life, that she had given Todd a warning before firing, that she had every reason to believe he would kill them both. But stand-your-ground cases are notoriously difficult for women to win. In Alabama, very few women had successfully used the defense since the law was adopted in 2006. Jackson County District Attorney Jason Pierce fought the motion aggressively. He argued that Todd was the victim, not Brittany. He pointed to the inconsistencies in her 911 call. He noted that forensic analysts found no evidence of Todd's genetic material in samples taken from her bed, though they did find secretions on her body. He argued she could have fled, that her brother was also an aggressor because he had brought a weapon into the situation. That lethal force wasn't necessary. In January 2020, Judge Jennifer Holt issued a 19-page ruling denying Brittany's stand-your-ground motion. Holt acknowledged the injuries documented by medical examiners: bruises, strangulation marks, bite wounds. But she wrote that Brittany had given inconsistent accounts of events, starting with the 911 call and her initial claim that Chris was the shooter. The judge also noted the lack of semen evidence, a common issue in cases involving assault, but one that undermined Brittany's credibility in court. Most critically, Holt ruled that Brittany hadn't proven she reasonably believed deadly force was necessary. The ruling devastated Brittany and her supporters. Advocacy groups across the country rallied behind her, arguing that the case exposed deep flaws in how stand-your-ground laws are applied. Statistics showed that men, particularly white men, were far more successful invoking the defense than women, especially women of color, or women in abusive relationships. Brittany's case became a flashpoint in debates over self-defense, victimhood, and the justice system's treatment of survivors. Brittany's trial was scheduled for February 10, 2020, but just days before, prosecutors indicted her on an additional charge: second-degree arson for allegedly setting fires inside a mobile home in Stevenson months earlier. The new charge increased her potential sentence significantly. Facing the possibility of decades in prison, Brittany accepted a plea deal. On October 9, 2020, she pleaded guilty to murder and arson. She was sentenced to 20 years for murder and 15 years for arson. Under the terms of the agreement, she would serve 18 months in prison, 18 months on house arrest, and then be on probation. She was released from prison in May 2021 and began her house arrest, but the conditions were strict, and Brittany struggled to follow them. In November 2021, she violated her house arrest by taking her children to a trunk-or-treat Halloween event. She was sent back to jail for 45 days. In September 2023, she violated probation again, this time for testing positive for substances and failing to complete a court-ordered rehabilitation program. She was arrested for the 6th time since her original conviction. Brittany's story was featured in a Netflix documentary released in November 2022 titled State of Alabama vs. Brittany Smith. The film explored whether women in the United States have equal access to self-defense protections under the law. It included interviews with Brittany, her family, legal experts, and advocates who argued that the system had failed her. The documentary sparked renewed conversations about Aniah's law and similar reforms, though Brittany's case predated those changes. Today, Brittany Smith remains under correctional supervision, her life defined by a night she insists was about survival. Her supporters continue to argue she never should have been convicted, that Alabama's Stand Your Ground law failed her because she was a woman, because she had a history of substance use, because she made the mistake of lying in the initial 911 call. Critics counter that the evidence was too inconsistent, that she could have escaped, that the law was applied correctly. What remains undisputed is that Todd Smith is dead, shot 3 times in Brittany's kitchen. Whether that death was murder or self-defense depends entirely on who you ask. For Brittany, the answer is clear. She did what she had to do to survive. For the courts, the answer was equally clear. She crossed the line. The case stands as a stark reminder that self-defense isn't always black and white, and that the legal system doesn't always see victims the way victims see themselves. But if Brittany Smith's case raised questions about individual violence and survival, the next case removed all ambiguity. Sometimes evil came not from desperation, but from ideology, and the damage it caused stretched across state lines and years. Case 5. Eric Rudolph, July 27, 1996, Atlanta, Georgia, the Summer Olympics. Millions of people had gathered to celebrate international competition, unity, and the ideals of global cooperation. Centennial Olympic Park was packed with spectators enjoying the festivities. Around 1:20 a.m., a security guard named Richard Jewell noticed an unattended green military-style backpack beneath a bench near the stage. He alerted authorities. The bomb squad arrived and confirmed Jewell's worst fear. The bag contained 3 pipe bombs surrounded by shrapnel, designed to maximize casualties. At 1:25 a.m., someone called 911 from a payphone. The voice was calm, almost robotic. "There is a bomb in Centennial Park. You have 30 minutes. The call disconnected. Police began evacuating the area, but there wasn't enough time. At 1:27 a.m., the bomb detonated. The explosion killed Alice Hawthorne, a woman who had traveled from Albany, Georgia, with her daughter to watch the games. More than 100 others were injured by flying nails, screws, and metal fragments. A news cameraman covering the aftermath suffered a fatal heart attack. The Olympic celebration turned into a crime scene. Richard Jewell, the guard who had discovered the bomb and likely saved dozens of lives, was initially hailed as a hero. Then, inexplicably, he became a suspect. The FBI and media outlets suggested he had planted the bomb himself to play the hero. His life was destroyed by the accusation. It would take months before he was fully cleared. Meanwhile, the real bomber had vanished into the night. Over the next 2 years, 3 more bombings followed. January 16, 1997. An abortion clinic in Sandy Springs, Georgia, just north of Atlanta. The first bomb exploded at the back of the building, causing significant damage. Exactly 1 hour later, as medical personnel, firefighters, and law enforcement worked to secure the scene, a second bomb detonated in the parking lot. 4 people were injured. The secondary device was designed specifically to kill first responders, a tactic that would become the bomber's signature. February 21, 1997. The Other Side Lounge, a nightclub in Atlanta. Another double bombing. Les Hunt, first device exploded on the rear patio, injuring 5 people. A second bomb was discovered before it could detonate, saving countless lives. Investigators found disturbing similarities between the bombs. Same construction, same shrapnel, same tactical approach. Someone was waging a calculated campaign of terror. January 29, 1998. Birmingham, Alabama. The New Woman, All Women Healthcare Clinic. Around 7:30 a.m., Nurse Emily Lyons and security guard Robert Sanderson, an off-duty Birmingham police officer, arrived for work. They noticed a package near the entrance. It looked like a FedEx box. As Sanderson leaned down to inspect it, the bomb detonated. The explosion was catastrophic. Sanderson was killed instantly. Lyons was thrown backward, her body pierced by nails and metal fragments. She survived, but required 37 surgeries. Shrapnel remained embedded in her legs for years. She lost most of her vision in one eye. This time, investigators caught a break. Two witnesses, Jeffrey Tickle and Jermaine Hughes, had been near the clinic that morning. They saw a man acting suspiciously and fleeing the scene. Hughes followed him and wrote down his license plate number. The information led police to a pickup truck registered to Eric Robert Rudolph, a 32-year-old man from Murphy, North Carolina. Authorities quickly connected him to the other bombings. In February 1998, he was officially charged in the Birmingham case. In October, he was charged in the 3 Atlanta bombings. On May 5, 1998, he was added to the FBI's 10 most wanted fugitives list with a $1 million reward. Eric Rudolph had disappeared into the Nantahala National Forest in western North Carolina. For more than 5 years, he evaded one of the largest manhunts in United States history. The FBI deployed hundreds of agents. They combed the mountainous wilderness. They interviewed locals. They set up surveillance. Rudolph, an experienced survivalist, seemed to vanish like smoke. Some speculated he had help from sympathizers who shared his anti-government, anti-abortion ideology. His family insisted he was innocent. Then, on May 31st, 2003, at 3 a.m., a rookie police officer named Jeff Postel was patrolling behind a grocery store in Murphy. He spotted someone rummaging through a dumpster. The man tried to hide. Postel approached and detained him. It was Eric Rudolph. After 5 years in the wilderness, he had been caught foraging for food. He surrendered without resistance. When they put him on the plane to Atlanta, witnesses said he had tears in his eyes. Rudolph faced the death penalty, but prosecutors offered a deal. In exchange for life in prison without parole, he would plead guilty to all charges and reveal where he had hidden 250 pounds of dynamite in the North Carolina forests. In April 2005, Rudolph accepted. At his sentencing hearing, he issued a statement explaining his motives. He said the bombings were acts of protest against abortion and what he called global socialism. He claimed the 1996 Olympics promoted values he opposed. He rationalized the deaths as collateral damage in a righteous cause. He showed no remorse. Judge Linwood Smith sentenced him to 4 consecutive life terms without parole. Rudolph was sent to ADX Florence, a supermax prison in Colorado, where he remains today. Emily Lyons attended the sentencing. She looked at the man who had destroyed her body and nearly taken her life. She said she wanted him to know the pain he had caused, the surgeries she endured, the pieces of metal still lodged in her flesh. Rudolph stared ahead, expressionless. In 2024, Rudolph filed an appeal challenging his life sentences, citing a Supreme Court ruling about vague sentencing laws. The 11th Circuit Court of Appeals denied his request, stating he was bound by the terms of his own plea deal. He had negotiated to spare his life and waived his right to challenge the sentences. The court's message was clear. Eric Rudolph would die in prison. The families of Alice Hawthorne and Robert Sanderson never got their loved ones back. Over 100 people live with scars, physical and emotional, from his bombs. Emily Lyons still carries shrapnel, and a movement that claims to value life used violence to make its point, leaving only death and suffering in its wake. Eric Rudolph's 5-year run as a fugitive proved that determination and ideology could sustain someone through unimaginable hardship. But in Citronelle, Alabama, another kind of determination would emerge. One fueled not by belief, but by methamphetamine and rage, leading to one of the most brutal family annihilations the state had ever seen. Case 6, Derek Dearman, August 20th, 2016. Citronelle, Alabama, a rural community 30 miles north of Mobile, where families lived on sprawling properties separated by trees and distance. On Jim Platt Road, at the end of a dead-end dirt lane, a house full of people slept peacefully. By sunrise, 5 of them would be dead, and the quiet of that Saturday morning would be shattered by an act of violence so brutal that investigators called it the worst mass killing in Mobile County's history. Derek Ryan Dearman was 27 years old, with an extensive criminal record in Mississippi and a reputation for violence when he used drugs. His girlfriend, Lynetta Lester, 24, had been trying to escape him. Friends and family described their relationship as turbulent and dangerous. Dearman had a temper, especially when things didn't go his way. Lynetta had fled to her brother's house in Citronelle, seeking refuge with Joseph Adam Turner and his wife, Shannon Melissa Randall. The couple had a 3-month-old son. Also staying at the house were Randall's brother, Robert Lee Brown, 26, and Randall's niece, Chelsea Marie Reed, 22, who was 5 months pregnant, along with her husband, Justin Caleb Reed, 23. On Friday night, August 19th, Dearman showed up at the house looking for Lynetta. Turner told him to leave. Dearman returned multiple times that evening, growing more agitated each time. Around 1 a.m., someone inside the house called 911 to report that Dearman was on the property. Citronelle police responded but found no sign of him. Officers checked the wooded grounds and left. The family went back to bed, believing they were safe. They were wrong. Sometime after 3 a.m., Dearman returned on foot. He had been using methamphetamine heavily. Later, he would tell investigators that the drugs made him paranoid, made him see things that weren't there. He grabbed an axe from a tree in the yard, broke into the house, and went room by room. Turner and Randall were asleep in bed with their infant son. Dearman attacked them with the axe while they slept. He moved to another room and did the same to Chelsea and Justin Reed. Then Robert Brown. All 5 victims were struck with the axe first, then shot with firearms he found inside the house. According to court records, after the initial attacks, Dearman went back and shot each victim again to ensure death. When he finished, Dearman found Lynetta and the baby unharmed. He woke her and forced her outside to talk. She was terrified. He demanded she stay with him, refused to leave without her. Eventually, he left the house, returned with the axe, and then forced Lynetta and the 3-month-old infant into a vehicle. He drove them to his father's house in Leakesville, Mississippi, about 30 miles away. Along the way, he made several stops, including a visit to another house where he continued using drugs. He didn't tell anyone what he had done. At his father's house, reality began to set in. The methamphetamine was wearing off. Dearman looked at Lynetta and the baby and realized the magnitude of what he had done. He told his father everything. His father convinced him to turn himself in. On August 20th, Dearman walked into the Greene County, Mississippi police station and surrendered. As he was being transferred to Alabama, he spoke to reporters. "Drugs were making me think things that's not really there," he said, his head hanging low. He claimed he spared Lynetta and the baby because he came down and realized what was really going on. Back in Citronelle, a family member had been trying to reach the Turners all day, Saturday, with no success. Late that evening, they went to check on them and found the horror inside: the bodies, the blood, the weapons. Police arrived and immediately issued a lookout bulletin for Dearman, warning that he could be armed with knives and swords. By the time they located him, he was already in custody in Mississippi. Mobile County prosecutors charged him with 6 counts of capital murder, 5 for the victims, plus 1 for Chelsea Reed's unborn child under Alabama's fetal homicide law. He initially pleaded not guilty, but later fired his attorneys and changed his plea to guilty. Because it was a capital case, Alabama law required the state to present evidence to a jury, even with a guilty plea. The jury heard the horrific details, saw the crime scene photos, listened to testimony from forensics experts. They unanimously found him guilty and recommended a death sentence. Dearman accepted responsibility. In interviews from prison, he said he was willing to give all that he could to repay his debt to society. He said the focus should be on healing, not on him. He said he knew what he deserved. In April 2024, he sent a letter to the court asking the state to proceed with his execution. "I am guilty," he wrote. "It's not fair to the victims or their families to keep prolonging the justice that they so rightly deserve." On September 4th, 2024, Alabama Governor Kay Ivey set an execution window for Derek Dearman between midnight on October 17th and noon on October 18th. In the days leading up to his execution, Dearman had visits from his sons, his sister, and his father. His final meal consisted of a seafood platter from a local restaurant. At 6:14 p.m. on October 17th, 2024, Dearman was executed by lethal injection at Holman Correctional Facility. He was pronounced dead shortly after. Alabama Attorney General Steve Marshall said the execution was in the interest of justice and finality for the families. The victims' relatives had mixed feelings. Bryant Randall, whose daughter Chelsea was pregnant when she died, said he believed drugs played a role and that maybe Dearman wasn't a bad person, but rather someone destroyed by addiction. Brooklyn Randall, Shannon's daughter, said the execution felt like tearing off a Band-Aid, reopening wounds that had never fully healed. Some family members said they had no hate for Dearman, but still believed in justice. The community of Citronelle held vigils. Prayers were offered, but nothing could undo what happened on Jim Platt Road. Derek Dearman's case became a stark example of how methamphetamine could turn a volatile personality into a killing machine. But it also raised questions about accountability, redemption, and whether someone high on drugs could be held fully responsible for actions they claimed not to remember. The courts decided yes. The families tried to move forward, and 5 lives, 6, counting the unborn child, remained forever lost to one man's chemically fueled rage. Yet methamphetamine wasn't always the drug at the center of Alabama's most calculated killings. Sometimes the weapon was far more subtle, hidden in plain sight, wielded by someone trained to heal rather than harm. Case 7, Nikki Capello, September 21st, 2018. Huntsville, Alabama. Marjorie Nicole. Capello, known as Nikki, filed a missing persons report for her husband James, a well-known private investigator in the area who went by Jim. His co-workers had been calling her, concerned because he hadn't shown up for work, something completely out of character for a man known for his dedication and reliability. When they went to the couple's home on Lauderdale Road to check on him, Nikki wouldn't let them inside. Jim's car was in the driveway, but she insisted she didn't know where he was. On September 22nd, Nikki made a phone call that would seal her fate. She called her close friend Crystal Anderson and confessed something unthinkable. Jim wasn't missing. He was dead. She had killed him with insulin, and she needed help disposing of the body. After a brief pause, Anderson on hold, likely in shock. Nikki came back on the line and told her not to worry about it. She said another friend was coming to help. Anderson hung up and immediately called police. Huntsville patrol officers responded to the house. One went to the backyard, another to the front door, covering all exits. When the officer at the front asked Nikki to step onto the porch to speak with him, he immediately smelled something unmistakable, the odor of a decomposing body. He detained her. The officer in the backyard spotted a small, freshly dug grave, a dirty shovel nearby, and muddy women's shoes. Investigators arrived, and the smell grew stronger as they approached the home. Detective Michael Denoon asked Nikki for permission to search inside. She became visibly nervous. She agreed, but told him he couldn't look in the garage. That was all the probable cause they needed. A search warrant was obtained. Inside the garage, investigators found Jim Capello's body wrapped in a tarp on the floor near a vehicle. His feet were positioned on the floorboard as if someone had been trying to load him into the car. Syringes and needles were found inside the house. A bottle of insulin was discovered, insulin that Nikki, a registered nurse, had no medical reason to possess. Detectives went to North Alabama Specialty Hospital in Athens, where Nikki worked, and learned that bottles of insulin had gone missing from the facility. Some of her coworkers later told investigators that Nikki had spoken about problems with her husband and allegedly said the only way those problems would end was if he died. The investigation revealed a troubled marriage. Jim had confided in his sister Jamie that he suspected Nikki had developed a narcotics addiction after using painkillers for a back injury. People close to the family had noticed her nodding off at strange times, even during meals. Jim, a trained investigator, began gathering evidence of her substance use. He had discussed placing a tracker on her car. He had been searching her belongings. He had even told his sister in a statement that would haunt her later, "If I'm found dead, she did it." At the time, Jamie didn't take it seriously. She couldn't imagine Nikki being capable of murder. But prosecutors believed Nikki had methodically poisoned her husband over time. Insulin, when given to someone who doesn't have diabetes, can be deadly. It lowers blood sugar to dangerous levels, causing confusion, loss of consciousness, organ failure, and eventually death. The needles are so small, they barely leave marks. And once a body begins to decompose, insulin becomes nearly impossible to detect. Nikki had likely been stealing the insulin from work for weeks, bringing it home bit by bit. When questioned, she claimed she had accidentally brought a bottle home. No one believed her. Jim's body had been in the garage for days by the time police found him. The medical examiner couldn't determine a definitive cause of death due to decomposition, a fact Nikki's defense team would later try to exploit. But prosecutors didn't need a medical cause of death. They had witness testimony. They had Nikki's own confession to Crystal Anderson. They had the insulin she shouldn't have possessed. They had the syringes. They had the freshly dug grave. They had coworkers who testified she had talked about Jim dying. And they had motive. Nikki wanted out of the marriage, suspected Jim was having an affair, and feared losing custody of their 4-year-old daughter if Jim's evidence of her drug use came to light. Nikki was arrested on September 24th, 2018, and charged with murder. She posted a $100,000 bond and was released that same night. In 2019, a grand jury indicted her on charges of reckless murder. But in 2021, prosecutors went back to the grand jury and re-indicted her on a charge of intentional murder, arguing the evidence showed premeditation and calculation. Her trial, delayed multiple times due to the pandemic and scheduling conflicts, finally began in May 2022. Over 4 days, 15 witnesses testified, all for the prosecution. Nikki's defense called no one. Her attorney, Brian White, argued that without a confirmed medical cause of death, the state couldn't prove Jim had been murdered, let alone that Nikki was responsible. He emphasized that insulin doesn't show up in a decomposing body after a certain amount of time, creating reasonable doubt. But prosecutor Shay Keller and District Attorney Tim Douthat argued that the evidence told a complete story. When you tell someone you're going to kill a man with insulin, when you're caught with insulin, when the man dies of what appears to be insulin poisoning, and when you tell someone else you killed that man with insulin, the cause of death becomes irrelevant under Alabama law. The jury deliberated for just over 30 minutes before returning a verdict: guilty of intentional murder. Nikki showed no emotion as it was read. Circuit Judge Alan Mann scheduled sentencing for July 14th, 2022. At the hearing, Nikki again displayed no visible reaction as Judge Mann sentenced her to life in prison with time served. Jim's family, who had sat through every moment of the trial wearing shirts that read "Justice for Jimmy" and "Prayers and Hope for Riley." Their young daughter expressed relief, but no joy. Jim's father said there would never be complete closure. Riley, now in the custody of Jim's sister, Jamie, would grow up without either parent. Nikki's defense team immediately filed appeals, arguing the conviction was based on insufficient evidence and that the state hadn't proven a crime occurred. In March 2023, the Alabama Court of Criminal Appeals upheld the conviction and sentence. Nikki filed a second appeal. It too was denied. She remains incarcerated, serving life in the Alabama Department of Corrections. A civil lawsuit was filed on behalf of Riley by attorney Will League, seeking compensation for the loss of her father. Any proceeds recovered would go toward her future care. The case became a grim reminder that monsters don't always look like monsters. Nikki Capello had been a nurse, a mother, someone trained to save lives. Instead, she used her medical knowledge to take one. Jim Capello had been a private investigator, skilled at uncovering secrets. The final secret he uncovered was that his own wife was planning his death. He just didn't act on it in time. But Jim wasn't the only person in Alabama whose investigation into someone close to them would end in tragedy. In Auburn, a college student's simple act of kindness would turn into a nightmare that exposed the failures of the state's entire bail system. Case 8, Ibrahim Yazid. October 23, 2019. Auburn, Alabama. Anaya Blanchard, a 19-year-old student at Southern Union State Community College, was enjoying a normal Wednesday evening. She dropped her brother Elijah off at his apartment around 11 p.m. and sent her roommate Sarah O'Brien a Snapchat message saying she was close to being home. Then, at 11:40 p.m., she sent another message saying she was with a man named Eric, someone she'd just met. Her location, shared through her phone, showed she was at an apartment complex nearby. Sarah assumed Anaya was hanging out with friends. By morning, it was clear something was wrong. Anaya never came home. Her phone went silent. Her family grew frantic. On October 24th, she was reported missing. Her Honda CR-V was found the next day at a Montgomery apartment complex, 55 miles from Auburn. The vehicle had damage along the passenger side. Inside, investigators found blood, so much blood that forensic analysts described it as indicative of someone suffering a life-threatening injury. The discovery sent chills through everyone involved. This wasn't a case of a teenager running away. Anaya Blanchard was in serious danger. Surveillance footage from a Chevron gas station in Auburn told a disturbing story. The video showed Anaya inside the convenience store around 11:20 p.m. on October 23rd. Also inside the store, at the exact same time, was a man later identified as Ibrahim Yazid. He was seen buying items, glancing in Anaya's direction. Additional footage showed him exiting the passenger side of Anaya's vehicle, then re-entering it. They left the gas station together, but a witness who had been at the store that night came forward with even more troubling information. The witness claimed to have seen Yazid force Anaya into her own car before they drove away. The witness told a companion what he had seen, but was told to mind his own business. He didn't call police until later. Ibrahim Yazid, 30 years old, was from Montgomery. He had an extensive and violent criminal record. In January 2019, he and 3 others had allegedly robbed and beaten 2 men at a hotel, leaving a 77-year-old man unconscious and near death. Yazid had been charged with kidnapping, attempted murder, and robbery. But despite the severity of those charges and his prior arrests, which included attempting to kill 2 police officers in 2012 by ramming his car into theirs, and aggravated battery on an officer in 2017. Yazid had been released on a $295,000 bond. He was out on the streets when Anaya Blanchard disappeared. On November 6, 2019, Auburn police released a surveillance image of a person of interest. The next day, that person was identified as Yazid. An arrest warrant was issued for first-degree kidnapping. A tip led authorities to Pensacola, Florida. The Florida Regional Fugitive Task Force located him near Interstate 10. Yazid fled on foot and refused to comply with officers' commands. Marshals physically removed him from his hiding spot. He was taken into custody and extradited back to Alabama. He has been held without bond at the Lee County Detention Facility ever since. While Yazid sat in jail, the search for Anaya continued. On November 25, 2019, authorities found human remains in a wooded area of Macon County, Alabama, between Auburn and Montgomery. 2 days later, they confirmed the remains belonged to Anaya Blanchard. An autopsy revealed she had died from a gunshot wound. Her death was ruled a homicide. The news devastated her family. Her stepfather, UFC fighter Walt Harris, and her mother, Angela Harris, had been holding out hope. Now that hope was gone. On December 2nd, 2019, prosecutors upgraded Yazid's charges to capital murder. Lee County District Attorney Brandon Hughes announced they would seek the death penalty. Hughes stated that investigators had determined Yazid was the sole person responsible for Anaya's abduction and death. However, 2 other individuals were also charged. Antoine Squirmy Fisher, 35, was charged with kidnapping for allegedly providing transportation to Yazid and disposing of evidence. David Johnson Jr., 63, was charged with hindering prosecution for lying to police about his son driving Yazid from Alabama to Florida. Court documents revealed additional chilling details. An unnamed witness told police they saw Yazid at a Montgomery residence wearing only shorts with a gun tucked into the waistband. The witness said Yazid had Anaya's vehicle but wouldn't let them see her. During a conversation, Yazid allegedly admitted to shooting a girl and said she went for the gun, suggesting Anaya had tried to defend herself. The statement contradicted any notion that this was an accident. Yazid had abducted her, driven her somewhere, and when she fought back, he killed her. In November 2022, a Macon County grand jury indicted Yazid on 3 counts of capital murder. 1 count during a kidnapping in the first degree, 1 count during a robbery in the first degree for taking her vehicle and cell phone, and 1 count involving a victim in a vehicle. Alabama. Attorney General Steve Marshall presented evidence to the grand jury for 10 days before securing the indictment. In March 2023, Yazid appeared in court and pleaded not guilty to all charges. His trial date was set for March 2nd, 2026, with jury selection beginning that day. But Anaya's story didn't end with the charges. Her death sparked a movement. The fact that Yazid had been out on bond, despite facing kidnapping and attempted murder charges, outraged Alabama residents and lawmakers. Anaya's family, led by her mother Angela, began advocating for Anaya's Law, a proposed amendment to Alabama's Constitution that would give judges and prosecutors more power to deny bond to suspects charged with violent crimes. Alabama's Constitution had long guaranteed the right to bail for all defendants, except those charged with capital offenses. Yazid's prior charges, kidnapping, attempted murder, weren't capital offenses, so he'd been granted bail. Anaya's Law would expand the exception to include serious crimes like kidnapping, rape, robbery, domestic violence, aggravated child abuse, assault, human trafficking, sodomy, sexual torture, terrorism, and murder. Under the new law, prosecutors could request a hearing to deny bond. Judges would have discretion to grant or deny based on evidence presented. The amendment was presented to Alabama voters during the general election on November 8, 2022. It passed overwhelmingly, a testament to how deeply Anaya's case had resonated across the state. For Anaya's family, the law was a bittersweet victory. It wouldn't bring her back. It wouldn't erase the pain of identifying her body through the sorrel boots Walt had bought her during a family trip to New York City, but it might prevent another family from experiencing the same nightmare. Angela Harris, Anaya's mother, became a voice for victims' families, speaking at events, sharing Anaya's story, and pushing for systemic change. Walt Harris publicly mourned his stepdaughter, describing her as kind, loving, and full of life. Anaya Blanchard's face became synonymous with the fight for bail reform in Alabama. Her story was featured in podcasts, news specials, and a 48 hours investigation that explored how a simple evening errand, picking up her brother, had turned into a fatal encounter with a man who should never have been free. Surveillance footage, witness statements, and forensic evidence painted a clear picture of abduction, violence, and murder. As of late 2025, Ibrahim Yazid awaits trial. If convicted, he faces either the death penalty or life in prison without parole. The families of Anaya Blanchard and the other victims in Yazid's violent history wait for justice. And Alabama's legal system, forever changed by Anaya's law, continues to grapple with the balance between the presumption of innocence and public safety. Anaya Blanchard was just 19 years old. She had her whole life ahead of her. One encounter at a gas station with a man on bond for violent crimes took all of that away. Yet even as Anaya's law aimed to prevent future tragedies, another Alabama case was unfolding, one where age was no barrier to unspeakable violence, and where a quiet morning routine would end in unimaginable horror. Case 9, Landon Durham. January 21st, 2020. Munford, Alabama. A small town in Talladega County where neighbors knew each other and children walked to school without fear. Around 3 a.m. that Tuesday morning, while most of Munford slept, 16-year-old Landon Durham allegedly moved through his family's home on Roy Lackey Lane with deadly purpose. His mother, Holly Christina Durham, 36. His twin brothers, Branson and Barron, both 13. Each of them was stabbed to death in their beds. Then, according to investigators, Landon went back to sleep. A few hours later, he got up, got dressed, and went to Munford High School as if nothing had happened. No one at school suspected anything. Landon attended his classes. He walked the halls. He sat in classrooms. Teachers didn't notice anything unusual about his demeanor. He was quiet, yes, but that wasn't out of character. What they didn't know was that less than a mile away, 3 bodies lay in a house that had become a crime scene without anyone realizing it yet. Back home, a family member had been trying to reach Holly and the boys all day Tuesday. Calls went unanswered. Texts were ignored. By evening, concern turned to alarm. The relative drove to the house to check on them. What they found inside would haunt Munford for years. Holly, Branson, and Barron Durham had all been stabbed multiple times. The scene was gruesome, violent, and pointed to someone who had killed with intention. The relative immediately called 911. Talladega County Sheriff's deputies responded and confirmed the worst. 3 people were dead, and the killer was missing. Investigators quickly determined that Landon Durham was unaccounted for. A lookout bulletin was issued to surrounding law enforcement agencies, warning that he could be armed with knives and swords. The search intensified overnight. On Wednesday morning, January 22nd, at approximately 7:45 a.m., Cherokee County Sheriff's deputies spotted Landon traveling in a vehicle on County Road 71 near County Road 38, heading toward Etowah County. He was pulled over and arrested without incident at a store across from Beans and Greens restaurant. It wasn't clear where he had been or where he was going. He simply surrendered. Talladega County District Attorney Steve Giddens held a press conference and confirmed what everyone feared. Landon Durham is the person who committed the crimes, Giddens said. He was arrested today. Giddens added that investigators believe the murders occurred around 3 a.m. Tuesday morning. The timeline was chilling. Landon had allegedly killed his family in the early hours, possibly gone back to sleep, attended a full day of school, and then remained at large overnight before his arrest. The sheer calmness required to pull that off left authorities stunned. At the press conference, Talladega County Chief Deputy Joshua Tubbs called it one of the worst things I've ever seen in his 19-year career. He didn't elaborate on the details, but the implication was clear. The violence inflicted on Holly, Branson, and Barron had been extreme. Giddens told reporters he didn't have a motive he could discuss publicly, though court records would later hint at family tension and behavioral issues. Under Alabama law, Landon was automatically charged as an adult because he was 16, and the crime was capital murder. He faced multiple counts of capital murder for killing more than one person in the same incident. However, because he was a minor at the time of the offense, he was not eligible for the death penalty. If convicted, the maximum sentence he could receive was life in prison without the possibility of parole. The town of Munford was devastated. A vigil was held 2 days later at Munford Baptist Church, drawing several hundred people. Relatives of the victims struggled to speak through tears. Jennifer Harrison, a relative, asked the community to pray for strength, for the victims to be in a better place, and for Landon to find his way. It was a remarkably compassionate statement given the circumstances, reflecting the close-knit, faith-based community's attempt to make sense of the senseless. Talladega County School Superintendent Suzanne Lacey released a statement acknowledging the tragedy and its impact on the school community. Like any small town, when tragedy strikes, it affects the entire community, including the school community, she said. Our focus is to support the school family during this difficult time. We have additional counselors available to provide a helping hand and listening ear to our Munford students and staff. Landon's preliminary hearing was scheduled for February 28, 2020, where a judge would determine whether there was enough evidence to proceed to trial. He was held without bond. In June 2021, Landon's defense attorneys requested that he be tried under Alabama's youthful offender status, a provision that would have eliminated a jury trial, sealed all court records, and capped his sentence at just 3 years in prison if convicted. Circuit Judge William Hollingsworth denied the request. Landon entered pleas of not guilty and not guilty by reason of mental defect, setting the stage for a trial that would examine his mental state at the time of the killings. As of now, Landon Durham, now 18 years old, remains in custody awaiting trial. The case has been delayed multiple times due to various legal motions and procedural matters. The question that haunts everyone is why? Why would a 16-year-old kill his mother and twin brothers? Was it premeditated? Was it a mental health crisis? Was there abuse in the home that pushed him over the edge? Prosecutors have remained tight-lipped, stating only that evidence will be presented at trial. What's known is that Holly Durham was engaged to be married. She had been building a life for herself and her children. Branson and Barron were just 13, still in middle school, with their whole lives ahead of them. Family photos posted on social media show smiling faces, a mother with her sons, a seemingly normal family. There were no public signs of the violence to come. The case raises uncomfortable questions about juvenile justice. Can a 16-year-old fully comprehend the finality of taking 3 lives? Should someone that young ever be sentenced to life without parole? Advocates argue that adolescent brains are still developing, that children can be rehabilitated, that locking them up forever ignores science and humanity. Others counter that some acts are so heinous that age becomes irrelevant, that society must be protected, that justice for victims matters more than second chances for killers. Landon Durham's story is still unfolding. A trial will eventually happen. Evidence will be presented. A jury will decide. But for the residents of Munford, the damage is already done. 3 people are dead. A community's sense of safety is shattered, and a teenage boy sits in jail charged with destroying his own family in the middle of the night before walking into school, like it was just another day. Sometimes the most terrifying violence comes from the people we're supposed to trust, our family, our neighbors, the systems designed to protect us. And as Alabama residents would learn from the final case, sometimes the greatest injustice isn't the crime itself, but what happens when the wrong person pays for it. Case 10, ToForest Johnson. The man Alabama may have wrongfully convicted, July 19, 1995. Birmingham, Alabama. Between 12:30 and 1 a.m., off-duty Jefferson County Deputy Sheriff William G. Hardy was working security at a hotel when he was shot twice and killed in the parking lot. The 49-year-old officer left behind a devastated family and a community outraged by the murder of one of their own. But the investigation that followed would become one of the most controversial, wrongful conviction cases in Alabama history. That same night, around 4 a.m., police stopped a car at a motel several miles from the crime scene. Inside were 4 African-American individuals: 22-year-old ToForest Johnson, his 21-year-old paraplegic friend, Ardrigus Ford, and 2 women named Latanya Henderson and Yolanda Chambers. They were detained and questioned, but at the time, investigators didn't have enough evidence to charge anyone. The case went cold for weeks. Then came the break prosecutors were looking for. Or so they thought. A woman named Violet Ellison came forward after the state announced a $5,000 reward for information. Ellison claimed her daughter was dating an inmate at the county jail and would make 3-way phone calls for him. Ellison said she picked up the phone during one of these calls and overheard a man who identified himself as ToForest confess to shooting Deputy Hardy. She also claimed the voice said someone named Quintez Wilson fired the other shot. There was just one problem. Ballistics evidence proved both bullets came from the same gun, meaning there was only one shooter. Ellison's story didn't match the physical evidence, but prosecutors moved forward anyway. Before ToForest Johnson ever stood trial, prosecutors tried Ardrigus Ford first. At Ford's trial, they presented a completely different theory. They relied on testimony from Yolanda Chambers, who claimed she saw Ford kill Deputy Hardy. Prosecutors admitted Chambers had lied in the past, but insisted she was telling the truth now. The lead detective testified that he believed Ford spun in his wheelchair, pulled out a 9mm weapon, and fired the shot. Ford's trial ended in a mistrial with a 10-2 vote in favor of acquittal. 1 month later, ToForest Johnson's first trial began. But now, prosecutors argued something entirely different. They no longer claimed Ford was the shooter. Instead, they said Johnson was the one who fired the fatal shots. Their entire case rested on Violet Ellison's testimony about the overheard phone call. No physical evidence connected Johnson to the crime scene. No eyewitnesses placed him at the hotel. In fact, more than 10 alibi witnesses testified that Johnson was at a nightclub across town when the shooting occurred. Johnson's first trial also ended in a mistrial because the jury couldn't unanimously agree on guilt. At Johnson's second trial in 1998, prosecutors presented yet another theory. Now they argued that Johnson and another man acted together. The story kept changing, but one thing remained constant: Violet Ellison's testimony. The jury convicted Johnson and sentenced him to death. He was sent to Alabama's death row, where he has remained for over 25 years. But questions about his conviction have never stopped. In 2015, Johnson's attorneys made a disturbing discovery. Violet Ellison had been secretly paid the $5,000 reward for her testimony. Prosecutors never disclosed this to the defense or the jury, a potential violation of constitutional rules requiring the disclosure of deals made with witnesses. The payment raised serious questions about Ellison's credibility. Was she a reliable ear witness, or was she motivated by money? Over the years, support for a new trial has grown. Jeff Wallace, the prosecutor who led Johnson's case, publicly called for a new trial, saying he no longer believes the conviction can stand. Jefferson County District Attorney Danny Carr, after reviewing the evidence, filed a brief supporting Johnson's request for a new trial. Carr noted that the evidence has unraveled over 20 years and that the foundation of the conviction has disintegrated. 3 former Alabama Supreme Court justices, 2 former governors, multiple former attorneys general, and dozens of legal scholars have all called for Johnson to receive a new trial. In 2021, 7 friend of the court briefs were filed supporting Johnson, an extraordinary outpouring from the Birmingham legal, faith, and activist communities. The Innocence Project filed briefs calling the case a textbook example of wrongful conviction. Former Alabama Attorney General Bill Baxley and former Chief Justice Drayton Neighbors joined the chorus. Defense attorneys from Birmingham, Montgomery, Tuscaloosa, and Mobile signed on. Religious leaders added their voices. Everyone, it seemed, except the Alabama Attorney General's office, agreed. Something had gone terribly wrong in this case. But in June 2024, Jefferson County Circuit Judge Candace Pickett denied Johnson's request for a new trial. She ruled that he had not proven his claim of prosecutorial misconduct and that he was barred from making a second post-conviction appeal. Johnson's attorneys filed new petitions citing District Attorney Carr's findings as fresh evidence warranting reconsideration. As of late 2025, those petitions remain pending. The case has been featured in the award-winning podcast, Ear Witness, by investigative journalist Beth Shelburne, who spent years examining every detail of Johnson's conviction. The podcast revealed inconsistencies, questionable tactics, and a justice system that seemed more interested in closing a case than finding the truth. Shelburne interviewed key players, including the lead detective, the lead prosecutor, and Violet Ellison herself. The investigation exposed what critics call an illusion of justice. DeForest Johnson is a father, a son, a brother. He was born and raised in Birmingham. His daughter, Shanae Poole, who goes by Akaria or Muffin, advocates for him on social media, sharing letters from death row and stories of visiting him in prison. His family has fought for over 2 decades for his freedom. They maintain his innocence. They point to the alibi witnesses. They point to the lack of physical evidence. They point to the ever-changing prosecution theories. And they ask a simple question. How can a man be on death row when so many people, including the prosecutor who convicted him, now believe he's innocent? The state of Alabama, represented by Attorney General Steve Marshall, continues to oppose a new trial. Marshall's office argues that Johnson had his day in court, that his previous appeals were denied, and that the courts have already ruled on these issues. But supporters counter that new evidence, including the payment to Ellison and the prosecutor's change of heart, justifies another look. DeForest Johnson has spent over 25 years on death row for a crime he insists he didn't commit. He was 22 years old when he was arrested. He is now in his 50s. More than half his life has been spent in a cell, awaiting execution for a murder that multiple witnesses say he couldn't have committed because he was somewhere else entirely. If he is innocent, it represents one of the most egregious failures of the Alabama justice system. If he is guilty, it means that over a dozen alibi witnesses lied, that the prosecutors accidentally got the right person despite changing their story 5 times, and that every legal expert calling for a new trial is wrong. The truth, whatever it is, remains locked behind years of legal procedures, sealed records, and a system reluctant to admit mistakes. Deputy William Hardy's family deserves justice. They deserve to know the person responsible for his death is being held accountable. But justice isn't justice if the wrong person is paying the price. And in the case of DeForest Johnson, The question isn't whether a crime occurred. It's whether Alabama has the right man, or whether an innocent person has been on death row for a quarter century while the real killer walked free. As Johnson's legal team continues to fight, as advocacy groups rally support, and as more voices join the call for a new trial, one thing becomes clear. Alabama's justice system is at a crossroads. Will it correct a potential wrongful conviction? Or will it execute a man despite overwhelming doubt? The answer will define not just Topherus Johnson's fate, but the integrity of Alabama's courts for generations to come.